Thank you for tuning in to the Brach Eichler Talks podcast, where we explore and discuss today's trending legal topics. In this episode, Brach Eichler attorneys J. Sabin Esquire and Ashley L. Matias Esquire discuss what contractors and owners need to know about stop work orders.
Hello, listeners. Thanks for tuning in. We're here to talk about our recent New Jersey Law Journal article regarding the New Jersey Department of Labor's authority to issue stop work orders. Our article has garnered quite a bit of attention, and since then, we have received plenty of calls from clients, particularly contractors. Hi, everyone. My name is Ashley Matias. I'm an attorney at the Labor and Employment Department here at Brach Eichler. I'm here with Jay Sabin, an experienced labor and employment attorney who has appeared before the Department of Labor and other government agencies and has walked contractors through the stop work order process every step of the way. So, Jay, let's start off with what brought us here today. Specifically, what led us to draft this article?
Thanks, Ashley. The New Jersey contractor community is enormous. It employs over 150,000 people, of whom nearly 2/3 are in the specialty trades. We wanted to write an impactful article, one that would help contractors focus on their wage and hour and wage payment compliance obligations. So, Ashley, let's start this off by talking about what exactly is a stop work order.
So, stop work order is an administrative directive, otherwise known as an injunction, that compels the recipient to cease all work. Some stop workers are directed only at a particular construction site, but others can be directed at an employer's entire workforce throughout the state of New Jersey.
And Ashley, who has the authority to issue a stop work order?
So, the New Jersey Department of Labor has the authority to issue these orders. So, Jay, can we explain to our listeners why the New Jersey Department of Labor would even issue a stop work order?
That's the key question, Ashley. A stop work order is a tool given to the Department of Labor to dissuade employers from failing to comply with our state's wage and hour and wage payment laws, and to compel the business that receives a stop work order to start complying with those laws. The New Jersey Department of Labor may issue a stop work order only after it has conducted an audit or an investigation of a business and has determined that the business is not complying with those wage and hour laws.
So, Jay, are there certain wage and hour laws that the New Jersey Department of Labor focuses on when they're deciding whether to even issue a stop work order?
Generally, yes. A very common focus of the New Jersey Department of Labor is worker misclassification, meaning a business that pays a worker as an independent contractor by 1099 when the person should really be considered an employee to be paid by W-2. Under New Jersey law, a worker is presumed to be an employee and not an independent contractor unless the business can prove three things about the worker. First, that the worker is free from control or direction over the performance of the work. Second, that the work is performed either outside the company's usual course of business or performed outside of the business's places of business. And three, that the worker is customarily engaged in an independently established trade, occupation, profession, or business. As some of our listeners know, this three-part analysis is referred to as the ABC test. So in conclusion, when the New Jersey Department of Labor determines that an employer has misclassified employees as independent contractors, it can issue a stop work order.
So let's switch gears and talk about what employers can do once a stop work order is issued against them. So there are options. A business can either contest the order or they can cut a deal with the New Jersey Department of Labor. Contesting the order is quite a process. It entails going before an administrative hearing officer and proving that the Department of Labor didn't have the grounds for issuing the order in the first place. If the hearing officer does not agree, a business can appeal the decision to an administrative law judge. Now, if the administrative law judge does not agree, the business can then appeal the matter to court. Until that order is overturned, it remains in effect and work cannot be performed. For contractors, specifically, this can be a nightmare. This can cause significant delays in job completion and potential issues with project financing. Now, alternatively, the business can enter into a settlement with the New Jersey Department of Labor. which usually includes payments to the workers and payments to the Department of Labor for administrative processing and administrative fine. It's not uncommon for the total settlement payment to far exceed the amount of monies or wages owed to the workers. Oftentimes, the settlement amount is multiples of that figure. Now, Jay, when we were researching for our article, what surprised you the most about stop work orders?
So Ashley, here's what we knew. We knew before we wrote this article that in 2019, New Jersey had greatly expanded the powers of the New Jersey Department of Labor to enforce our state's wage and hour laws. And we also knew that as part of that 2019 expansion, the state had authorized the New Jersey Department of Labor to issue stop work orders. But we didn't expect to find just how often these orders are being issued by the New Jersey Department of Labor. According to our research, the Department of Labor is issuing stop work orders at the rate of one every 10 days. And more than 80% of those stop work orders have been issued to contractors. Frankly, that surprised us greatly.
Wow, that is a whole lot of projects being postponed. So now that we know stop work orders are a real possibility, especially for contractors, Jay, can you give our listeners some advice on what they should do?
For sure. The wage and hour and wage payment laws of New Jersey are voluminous. In addition, there's other requirements and obligations for contractors who work on public work projects, and we haven't even covered those today. Our advice is that no contractor should bid on a project or hire workers without making sure that they can comply with these laws. A stop work order can be like a workplace death penalty, resulting in financial and reputational losses.
So there you have it, everyone. Thank you for tuning in. For those of you who have any questions or concerns about your wage and hour practices, we are here to help. You can find our contact info in the caption, or you can visit bracheichler.com. For those of you who would like to read our New Jersey Law Journal article, that link is also in the caption.
For more information or assistance, please contact J. Sabin, Esquire, Member, Labor and Employment Practice at jsabin@bracheichler.com or 917-596-8987 or Ashley L. Matias, Esquire, Associate, Labor and Employment Practice at amatias@bracheichler.com or 973-364-8330. This is intended to provide general information, not legal advice. Please contact the authors if you need specific legal advice. Brach Eichler LLC is a full-service law firm based in Roseland, New Jersey, with over 80 attorneys. The firm is focused on the following practice areas: healthcare law, real estate, litigation, trusts and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property, and information technology, real estate tax appeals, tax and cannabis law.